Parental alienation in Illinois.
When two parents decide to no longer continue their relationship with each other, they still must maintain a relationship with the children. When one parent's relationship with his or her child is harmed by the other parent, the term parental alienation is often invoked by psychiatrists and family law attorneys. What is parental alienation? Parental alienation syndrome is a term coined in 1985 to describe a distinctive suite of behaviors in children that includes showing extreme but unwarranted fear, disrespect, or hostility towards a parent.
Illinois courts have specifically said to throw out the words parental alienation syndrome.
In expressly disclaiming any reliance on the parental alienation syndrome theory, in Re Marriage of Bates, 212 ill.2d 489, 289 ill. Dec. 218, 819 NE 2d 714, ill.
2004.
Instead, Illinois law has a variety of statutes and procedures to prevent and discourage anything that looks like parental alienation. Establishing a parenting plan that prevents parental alienation. When two parents break up and begin court proceedings in Illinois to formalize that breakup via divorce or parentage petition, the parties are required to submit a proposed parenting plan. If one parent submits a parenting plan with little to no parenting time or decision-making, the initial case for parental alienation can be made using their court filings. If the parenting plan exhibits the initial signs of parental alienation, or a parenting plan hasn't been submitted at all, then a motion for temporary parenting time must be filed to stem any possible parental alienation.
Temporary parenting time as an immediate cure for parental alienation in Illinois.
An obvious cure for one parent poisoning a child's mind about the other parent is to simply let the child spend time with the other parent. At any point during an Illinois divorce or parentage action, either parent can request from the courts immediate parenting time with their children. An Illinois family law court will make the exact same considerations when setting temporary parenting time as they do when establishing permanent parenting time and parental decision-making. Illinois courts base all parenting time decisions of the best interests of the child after considering all of the available evidence. If it is alleged that the other parent continues to hamper the relationship between a parent and a child, a third party must get involved to investigate.
Guardian ad litem's, child representatives and parental alienation in Illinois.
A judge cannot be expected to get to the bottom of emotionally charged allegations.
In Illinois, family courts appoint guardian ad litem's and child representatives to investigate the facts. Guardian ad litem's and child representatives are attorneys who represent the best interests of the child. A guardian ad litem issues a report after their investigation, whereas a child representative does not issue a report. A guardian ad litem can also provide testimony to the court regarding their findings, and a child representative may merely present outside evidence like any other attorney. The guardian ad litem will interview both parents, the children, and any other person who may have interacted with the parties. Proving parental alienation in Illinois is largely the responsibility of the guardian ad litem's investigation and report. You will still have to advocate to the guardian ad litem to outline what actions have occurred that could constitute alienation and what recommendations are being made to prevent any future alienation. Court-ordered psychiatrists in an Illinois parental alienation matter. A parent may be making disparaging remarks about the other parent in front of the child. Less obviously, a parent may be making subtle inferences that discourage a child in their relationship with their parent. Then the child internalizes these behaviors and makes a conscious or unconscious decision about their relationship with the other parent. Alternatively, the other parent may simply be hostile or unpleasant to the point that the child cannot develop a loving, secure relationship with him or her. An unbiased psychiatrist is usually appointed by the court to make that determination and issue a report to the court and all parties. The court's professional has a lot of duties because their recommendations will determine parenting time and parental responsibilities. If the case is so heated that both parties know in advance that they will each need their own evaluator, they can ask the court to reject appointing a court's professional and each retain their own evaluator at their own cost. Both the court professional and an evaluator's report must contain the following sad face: 1. A description of the procedures employed during the evaluation. 2. A report of the data collected. 3. All test results. 4. Any conclusions of the professional relating to the allocation of parental responsibilities under sections 602.5 and 602.7. 5.
Any recommendations of the professional concerning the allocation of parental responsibilities or the child's relocation. And 6. An explanation of any limitations in the evaluation or any reservations of the professional regarding the resulting recommendations.
Parental alienation post-divorce.
As time passes and people change.
Children grow up. Parents get into new relationships.
Challenges can arise in life that lead to, or look like, parental alienation. If something like parental alienation is occurring, you can ask the court to enforce your allocation of parenting time, and parental decision-making should include a clause forbidding disparagement of the other parent.
The real solution to parental alienation.
In the alternative to holding an alienating parent in contempt or modifying the parenting schedule, the Illinois Marriage and Dissolution of Marriage Act has a statute that is perfect for both the punishment and resolution of alienating behavior. 750 ILCS 5607.5. The abuse of allocated parenting time. This statute simply requires a showing that one parent did not comply and then allows the court to provide a slew of possible solutions including make-up time, counseling and attorney's fees.
Real, actual parental alienation can be so extreme that it must be addressed on a day-to-day basis.
The only way to effectively investigate and even supervise a parent's behavior is to hire a parenting coordinator. A parenting coordinator is a third party, usually someone with a therapist's or social worker's background, who on a day-to-day basis will direct the parents in both when and how they parent.
Changing custody because of parental alienation.
If one party consistently and clearly alienates the children from their other parent and everyone agrees, the physical custody of the child may be transferred to the alienated parent. An Illinois divorce court can completely transfer custody based on evidence of alienation.
Complete removal of the child from the alienating parent is unlikely, but equal parenting time is very likely. If you believe your children's other parent is engaging in parental alienation during or after your Illinois divorce, contact the law office of Russell D. Knight today. Call us at 773-334-6311 to discuss all of your options with an experienced Chicago divorce lawyer.